The Supreme Court said Congressman Michael Bost, as a candidate for office, can bring a lawsuit over Illinois' way of counting certain mail-in ballots. Illinois allows ballots that are postmarked or certified by Election Day to still be counted if they arrive within 2 weeks after Election Day. A lower court had thrown the case out, saying Bost didn't have the right to sue. The Supreme Court disagreed and sent the case back to the lower courts to keep going. Chief Justice John Roberts wrote for the court. The majority said candidates have a real personal stake in the rules used to count votes in their own elections, even if they can't prove the rule will make them lose, or even if it doesn't drive up their campaign costs. The court said this is about the integrity of the election and the democratic process itself. Justice Ketanji Brown Jackson dissented, joined by Justice Sonia Sotomayor. Justice Amy Coney Barrett agreed with the result in a separate opinion, and Justice Elena Kagan joined that. We'll dig into what this means for election challenges going forward, and why this question of who can sue may shape the next fight over mail-in voting rules. Nine Robes uses non-partisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided, it's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. Congressman Michael Bost and other political candidates sued over an Illinois election rule that allows mail-in ballots to be counted if they're postmarked by Election Day but arrive up to 2 weeks later. The candidates argued this violates federal law, which sets a single, uniform election day for congressional and presidential elections across the country. Lower courts threw out the case, not because the candidates were wrong about election law, but because the judges said the candidates hadn't proven they were harmed enough to even bring the lawsuit in the first place. This is called standing, and it's a fundamental requirement before any federal court can hear a case. The Supreme Court took up the case to answer one key question: do candidates have the right to challenge election rules in court, or must they first prove those rules will cause them to lose? Chief Justice Roberts, writing for the court's majority, ruled that Congressman Bost does have standing to challenge the vote-counting rules. The court sent the case back to the lower courts to actually decide whether Illinois' rule violates federal election law. The court's reasoning centered on what it means to be a candidate in an election. According to the majority, candidates have more at stake than just winning or losing. They have a personal interest in making sure the election is run lawfully and fairly, and in ensuring the results are seen as legitimate by the public. The court rejected the idea that candidates must show a substantial risk of losing their election before they can challenge election rules in court. The justices warned that requiring this kind of proof would create serious problems. It would force candidates to wait until right before an election, or even after votes are counted, to file lawsuits. The court has repeatedly cautioned against last-minute court battles over election rules because they create chaos and confusion for voters and election officials alike. The majority also pointed out that asking judges to predict election outcomes would put courts in an impossible position. Judges aren't political analysts, and making them guess who's likely to win an election would look more like partisan forecasting than legal analysis. Justice Barrett, joined by Justice Kagan, agreed that Congressman Bost should be allowed to sue, but for different reasons. She criticized the majority for creating what she called a novel special standing rule just for candidates. Instead, Barrett argued that Bost has standing based on a more traditional legal concept: financial harm. According to Barrett, campaigns have to spend money on poll watchers and monitoring systems to protect against problems that might arise from counting ballots that arrive late. These are real, out-of-pocket costs that campaigns wouldn't have to pay if the rule didn't exist. Barrett worried that the majority's approach strays too far from established legal principles. She emphasized that all people who sue in federal court, including political candidates, should have to meet the same basic requirements to prove they've been harmed. Justice Jackson, joined by Justice Sotomayor, disagreed entirely. She argued that Congressman Bost hasn't suffered any real concrete injury and therefore shouldn't be allowed to sue at all. Jackson's main concern is that the majority is turning standing from a requirement to prove actual harm into an automatic right based on someone's status as a candidate. She pointed out that everyone, not just candidates, cares about fair elections and legitimate results. If caring about election integrity is enough to sue, then anyone could challenge any election rule, which would overwhelm the courts with lawsuits. Jackson also rejected Justice Barrett's financial harm theory. She argued that spending money to monitor an election doesn't create standing if the underlying harm you're worried about is too speculative. In her view, Bost is spending money to guard against problems that might never happen, which isn't enough to justify a federal lawsuit. Finally, Jackson warned that the majority's decision could open the floodgates to candidate lawsuits about all sorts of election procedures, from how ballots are designed to how they're transported and stored, even when candidates can't point to any specific harm those rules cause them. The real legal debate in this case isn't about whether Illinois' mail-in ballot rule is legal. The Supreme Court didn't decide that question. Instead, the justices disagreed about a more fundamental issue. What does someone have to prove before they can challenge election procedures in federal court? Being a candidate gives you a concrete personal stake in how elections are run. Candidates have a unique interest in making sure the process is lawful and the results are seen as legitimate. This interest is specific enough to allow candidates to sue without having to prove they'll lose because of the rule they're challenging. Candidates should have to meet the same standing requirements as everyone else, but they can do so by pointing to the real money they spend responding to potentially problematic election rules. You don't need a special candidate standing rule. Traditional legal principles work just fine. Justice Jackson's view: standing requires proving you've suffered, or will imminently suffer, a concrete particularized injury. Caring about election integrity, even as a candidate, because that's a concern shared by all citizens. And spending money to monitor elections doesn't create standing if the harm you're worried about is too uncertain. The timing dilemma. The majority emphasized a practical problem. If candidates have to wait until they can prove a rule will cause them to lose, they'll file lawsuits at the last minute, creating chaos right before elections. But Jackson countered that practical concerns can't override the Constitution's limits on federal court power. The manufactured standing debate. Barrett argued that campaign spending on poll watchers is a real cost that creates standing. Jackson called this manufactured standing. Voluntarily spending money in response to speculative harms shouldn't give you the right to sue. These competing views reveal a fundamental disagreement about election cases. Should courts recognize that candidates have special process-based injuries that allow them to challenge election rules? Or does doing so water down the requirements for bringing a lawsuit and open the door to endless political litigation? The majority believes candidates need a meaningful way to challenge potentially unlawful election rules before it's too late. The dissenters worry this approach gives candidates, and by extension political parties, too much power to drag election procedures into federal court without proving real harm. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.